For that.
Mr. Armstrong?
So, morning, good.
Good morning.
I don't know what order you want to go in. I know we're ready for the sentencing and the couple things. I've got the victim on. Christopher Navarro was on Zoom. I just called her again. She'll be here within 30 minutes.
I'm sorry?
The victim on Christopher Navarro.
Why are they not here?
She got a little nervous this morning. She has a kid that she's taking care of, so she's coming down with the baby. I told her to be here in person, Judge. Yesterday when I spoke to her.
On the record in the matter of the people of the state of Michigan versus Crystal and Quick 24-02397. Is that your matter, Mr. Searles?
I'm sorry, I had a little trouble.
Crystal and Quick, yeah.
Quick, yes, thanks, sorry.
Eric?
Thank you, Your Honor. Sorry. Good morning, Your Honor. Case Mark Arian appearing on behalf of the people. Make a motion to practice on court number 8.120.
Good morning, Your Honor. Jacob Starks, the fourth assistant public defender here on behalf of Ms. Quick. She's present at council table. She's standing to my right. Thank you.
Okay, Ms. Quick, today was the date that was scheduled for sentencing. That was pre-sentence report that was prepared on the 31st. Council, did you get a copy?
I did, Your Honor. Thank you.
We need to make corrections, updates, or deletion.
No, Your Honor. Thank you.
Address the court.
Thank you, Your Honor. Ms. Quick is very sorry for her poor decision-making and the loss of money to her employer. She understands at the time that she just made a very poor choice. But respectfully, Ms. Quick does not have a prior criminal history to the best of my knowledge. She is an excellent candidate to complete probation successfully. She will make every effort to pay back the restitution. She understands how important it is to be very careful, especially when you're handling an employer's money. And she'll make the proper steps in the future to make sure that something like this never happens again. She's gainfully employed right now. She has a good job. She has plenty of support from her family. Her husband's here with her this morning. So respectfully, Your Honor, I just ask the court to follow the recommendations here. And Ms. Quick will try to pay off the restitution as soon as she's financially able to do so. Thank you.
How did you find when you make a statement?
My judgment.
Apologies, but not necessarily owed to the court, it's owed to the victim. I don't think we have any representative of the victim here.
No, Your Honor.
I don't even have a victim impact statement. Obviously, this is a business. And you were in a position as a manager at that business, at least at that location. There was some trust that they had in you that was breached. And I did read the pre-sentence report in the interview. I understand that you take full accountability for that, that you're remorseful, that you were going through hard times. And it's really unfortunate because you allowed your temporary situation to put you in this position where you were originally charged with a felony that faced, some prison time over a situation that you could have navigated it in a different route that would be more beneficial to you and to your family and to whatever end or cause you were trying to accomplish. You see, it didn't work well. And so I agree that you would be a good candidate for a term of probation. But for the large amount of restitution, I probably would have reduced the amount of time that's being recommended because of your lack of previous criminal history, but I think that you need oversight for the bare minimum of making sure that payments are being made consistently. So I will adopt the recommendation. You can place on a term of probation before the court. For 12 months, however, I will make it non-reported.
Thank you, Your Honor.
Your requirements will be to maintain employment and make monthly payments on your restitution. Restitution is going to be ordered in the amount of $7,000. $943. Provide evidence of employment. Okay. Okay. You'll provide to the.
Oh,
probation
yeah,
department.
yes, sorry.
Okay.
I'm sorry.
Okay. I'll waive the oversight fees. However, there is a $75 crime victim rights fee that must be assessed plus a $50 state minimum cost. That also must be assessed. I'll waive discretionary fines and costs.
Thank you, Your Honor.
You're welcome. It's $8,068. And how much do you anticipate you'll be able to afford to pay monthly on that restitution?
We're looking after I sent yesterday and looked out.
Now, note here that you'll be paying a minimum of $150 per month. Probation will go over the sentence of the court and they'll put it in writing. You'll review and sign it. Do you have any questions?
No,
Okay. Last thing is there should have been an advice of rights. That's a probation added to this file. I don't see it. The advice of rights indicates that you've been placed on a term of probation before the 54A district court, and the terms are individually tailored and specific to address your assessed risk and needs. And so you would have the right to request early discharge from probation once you've completed half the original term ordered by the court, so long as you've not had any violations. You get that term, no violations within the 90 days preceding that request. You would make the request by using the court's MC 512 form that's on the court website, or you can get a copy from the probation officer directly. You complete that request, you file it with the probation office, but you also got to file a copy with the prosecutor's office. The prosecutor has 14 days to respond in writing with any objections to your early discharge, okay? You can file it electronic, meaning you can take it to, email it to your probation officer. You do have to file it in person over at to serve the prosecutor's office, okay? But you can get the form offline, okay? And your probation officer is able to make that request on your behalf as well. The other issue is if there is a hearing set to address the early discharge request, you do not have the right to court-appointed counsel for that. You could hire an attorney for that if that's what you wanted to do. I've never held a hearing for early discharge. Do you have any questions about that, right? I just need you to initial that you were advised of your rights to early discharge. Yes, please.
Thank you.
Okay, you'll go downstairs and check in with probation before you leave today, and then you'll be all set. Amen. Any additional matters for the record?
Nothing from the people.
Nothing further, Your Honor. Thank you.
Thank you. You're all set.
We're ready on both Engstrand and James, Your Honor.
We have an interpreter here on,
Yeah, Your Honor.
It's not, he's here.
oh, sorry. Are we running that?
I have not seen the necessary witness on that. I'm not running it there.
On the record in the matter of the people of the state of Michigan versus Marcelli Sequin Ismata, 24-01139. Council appearance.
Morning, Your Honor. Case marked Aaron, appearing on behalf of the people.
Morning, Your Honor. Robert Palmer, Public Defender's Office, on behalf of the defendant who is approaching right now. There's also an interpreter by the name of
Jose
Jose.
Castillo, Your Honor.
Can you spell that, please?
JOSECASTILLO.
Raise your right hand. You solemnly swear or affirm to interpret the matter before the court completely and accurately and not divulge confidential communication.
I do, Your Honor.
Thank you. Today's the date that was set for preliminary examination. And the prosecution indicated they do not have the necessary witnesses.
No, Your Honor. I communicated with the necessary witness, Yesenia Santiago, yesterday. When I spoke with her, she advised she had work. I told her that that was not an excuse to not show up to court. She advised that she confirmed receipt of her subpoena. She knew she had it, and she said she was not planning to attend. I let her know that the likely outcome of that would be a dismissal by the court if the people are unable to proceed.
Thank you, Your Honor. At this time, the defense would move to dismiss for lack of probable cause.
Motion to dismiss is granted without prejudice. The people have the right to reissue the charge against you, okay, sir?
Okay.
Do you have any questions?
¿Alguna pregunta para ella? No, Your Honor.
The additional matters for the record?
Nothing from the people.
Nothing from the defense.
When Yolanda comes back, I'll get a copy of this.
Thank you, Judge.
Thank you. On the record in the matter of the people of the state of Michigan versus Blake Engstrand, 24-03195. Appearance, please.
Morning, Your Honor. Case marked Aaron, appearing on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Engstrom.
So Engstrand had a schedule for today. There was an offer to plead guilty to an added count 2 of aggravated domestic violence. My understanding is that there's going to be an unconditional waiver today.
That's
Yes.
correct, Judge. Thank you.
No problem. I need a dismissal for that one.
I'm sorry.
You can print a dismissal for that one. Okay, Mr. Engstrand, you understand that you have the right to have a preliminary examination in this file in the district court.
Yes, Your Honor.
You understand that you have the right to require the prosecution to put forth evidence to establish that they have sufficient probable cause that the felony was committed and probable cause sufficient to charge you with the felony. You understand that?
Yes, ma'am.
You wish to unconditionally waive your examination?
Yes, ma'am.
Anybody threatening you to do that?
No, Your Honor.
Is there any promises made for you to give up your exam today?
No, Your Honor.
Was there any other offer or will further negotiations happen at circuit court?
I assume they will, Your Honor. I can't say for sure.
Right, waiver to be freely and voluntarily given. Your bind over date's gonna be November 20th. You do not have to appear in court on November 20th. That's the date the circuit court is gonna get the file from the district court, okay?
Yes, ma'am.
Your next court date will be a pretrial. Your attorney will be made aware of that. Your bond was set at 2,000 personal recognizance with GPS tether and victim notification that will continue not to be within 2,000 feet of the victim. And as you must provide an address. You did provide an address of where you're staying now.
Yes, Your Honor.
Where is that?
Bassett Street at my brother's house.
Excuse me?
It's South Lansing, I believe it's Bassett Street. I'm sorry. Bogart.
What address do we have for him? Okay. Your phone number ends in 1053.
Correct.
Any additional matters for the records?
Nothing from the people.
No, Your Honor.
You're all set, sir.
Thank you, Your Honor.
We do casino right now if you want, Your Honor, I think. Should be.
On the record in the matter of the people of the state of Michigan versus Francisco Cristino, 24-03223, counsel appearance.
Morning, Your Honor, case from our parent appearance on behalf of the people.
Good morning, Your Honor.
Okay, Mr. Cristino had a preliminary examination on 2 counts of controlled substance possession. And so the people are offering for you, Mr. Cristino, to plead guilty to added count 3 of controlled substance use of methamphetamine, and an added count 4 of controlled substance use of narcotic. Both misdemeanors, maximum penalty 1 year and or $2,000 in fines. In exchange for your plea, they will dismiss counts 1 and 2. Here's a killer blue to no upfront jail. Is that accurate?
Yes, Your Honor.
Swan,
Yes, Your Honor.
and you want to accept that plea offer?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Okay, I have an advice of rights and plea information sheet with today's date on it, sir. Is that your signature?
Yes.
Did you
Yes,
go
Your
over
Honor.
these rights with your attorney?
Yes, Your Honor.
You understand each of those rights?
Yes, Your Honor.
You want to give these rights up today in order to accept the offer to plead guilty to 2 misdemeanors?
Yes, Your Honor.
You understand that you have the right in this matter to the presumption of innocence. So that means you're innocent until proven guilty, and you have the right to require the prosecutor to prove your guilt by proceeding to jury trial. They would have to prove each element of the charges being brought against you beyond a reasonable doubt. You understand that, right?
Yes, Your Honor.
You want to give up your right of the presumption of innocence and your right to have a trial?
Yes, Your Honor.
You also have the right to remain silent at any trial and not have silence be used against you. You have the right to see, hear, or question in court any of the witnesses that the prosecutor was going to call to testify against you. You have the right to have witnesses subpoenaed on your behalf to testify, or you can waive your right to silence and testify at your own trial if you like. All of those are rights that you will give up in addition to your presumption of innocence if you waive those rights today. You understand that?
Yes, Your Honor.
Is anybody threatening you to get you to give these rights up?
No, Your Honor.
Has there been any promises made in exchange for you giving up these rights?
No, Your Honor.
You're currently on probation or on parole.
No, Your Honor.
You understand that if you plead guilty to the amended or the added count 2 and 3, added count 3 and 4, that is, that you could get a conviction that may have impact on your job. You have to report it to your job or report it on a future job application. You understand that?
Yes, Your Honor.
It also could have impact on immigration or travel status that you may seek in the future. You understand that?
Yes, Your Honor.
As to added count 3 of controlled substance use of methamphetamine, how do you plead?
Guilty.
And as to the added count 4 of use of narcotics, how do you plead?
Guilty.
Actual basis, counsel.
Thank you, Your Honor.
on October 22nd, 2024, were you at the corner of Catherine Street and Holmes Road?
Yes,
And is it in Lansing?
yes,
And to the best of your knowledge, is it in that county?
yes,
And at that time, did you use methamphetamine?
yes,
And when you use methamphetamine, you knew that it was methamphetamine?
yes,
And at that time, do you had any legal authority or any prescription to use the methamphetamine?
no,
And also that same day at the same place, did you use heroin? And you knew that it was heroin?
yes,
And did you had any legal authority or prescription to use that? Did you had any legal authority or any prescription to use?
no,
Any questions from the prosecution?
No, Your Honor, the people are satisfied with the factual basis.
The board is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently.
Your Honor.
Your matter is going to be set for sentencing, November, I'm sorry, what's the sentencing date? January 10th at 9 a.m. You will leave here, go downstairs today to our probation department. So you can check in for a pre-sentence interview. They'll get you scheduled for that today, okay?
Okay, thank you, Your
You
Honor.
are going to be required to undergo a substance abuse assessment prior to your sentencing. You have any questions at this time, sir?
Oh, Your Honor.
We'll get you your notice to appear, and then you'll go in and check in with probation so that you get instructions about your pre-sentence interview and your substance abuse assessment that needs to be scheduled, okay?
Okay, thank you, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people.
Something for the defense, yeah.
Thank you. You're all set.
Thank you.
Thank you.
We're ready to do the plea on James, Your Honor. If I could just have a moment to check the call real quick. I think I heard a baby, so that might be the victim on the bar.
Ready to sit down? Yes.
No, no, sorry, sorry.
Oh, that's it. It's not still here. It's not still.
I think so. On the scale website, did you go on the scale website? Google scale, I see, you know. They have a section for forms.
Yeah.
She said she was fine.
Okay.
She said she would put it in the ship.
Okay. Yeah, he's gonna get like a figure.
Your Honor, I think we're ready on James, Williams, Bywater, whenever you are. The victim on Christopher Navarro just advised she was about 5 minutes away. She was on Saginaw, so she'll be here soon.
Thank you. You might have left already. Mr. Palmer's client leave. Mr. Palmer's client leave.
No.
Where is he outside? Yes.
That's what you gave me.
This is gonna put on. Okay. And we're ready on James.
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Calvin James, 24-3198, counsel defense.
Good morning, Your Honor. Case Mark Herring appearing on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. James.
Okay, Mr. James had a exam scheduled today. It's a 911 call. My understanding is there's going to be a plea.
There is, Your Honor, may I approach?
Yes. So, Mr. James, you want to plead guilty to the count of domestic violence, misdemeanor, a maximum penalty 93 days in jail and or $500 in fines, with a agreement to no objection to sentencing under 769.4A if eligible?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Thank you for putting your hand down. This is your rights and rights. Is that your signature?
Yes, ma'am.
Did you go over these rights with your attorney?
Yes, ma'am.
You understand each of the rights that are listed here?
Yes, ma'am.
You want to give them all up in order to plead guilty to count two?
Yes, ma'am.
So that means you're gonna give up your right to the presumption of innocence. That means you're innocent, sir, and so proven guilty. And you have the right to require the prosecution prove your guilt. They have to prove each element of the charges being brought against you beyond a reasonable doubt at your trial. You have the right to jury trial. You have the right to remain silent and not have that silence be used against you, or you can waive your silence at trial and testify if you'd like. You have the right to subpoena witnesses to testify on your behalf at your trial. You have the right to see, hear, and question any other witnesses that the prosecutor calls at trial to testify against you. You understand those are rights you would give up?
Yes, ma'am.
Anybody threatening you to give these rights up?
No, ma'am.
Any promises being made in exchange for you pleading guilty to count two?
No, ma'am.
Are you currently on probation?
Yes, ma'am.
Which court?
Oops.
Oh,
You're not
no,
currently
ma'am.
on
No, ma'am, I'm not.
Oh, okay. Are you currently on parole?
No.
I understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
Yes, ma'am.
It also could have impact on travel or immigration status that you may seek. You understand that?
Yes, ma'am.
As to the sentencing agreement, there's no objection to sentencing under 769.4A. We don't know how you're gonna be sentenced yet. You understand that?
Yes, ma'am.
As to count two of domestic violence, how do you plead? Factual basis?
Yes, Your Honor. On October 19th of 2024, were you in the area of 3407 West Mount Hope in the city of Lansing, County of Ingham, State of Michigan? And were you there with a Monica Vanda?
Yes.
And were you previously in a dating relationship with Ms. Vanda?
Yes.
And on that date and time, did you guys get into an altercation?
Yes.
And during the altercation, you attempted to grab the phone that was in her hand,
Yes.
and she did not consent for you to do that?
Yes.
Any questions from the prosecution?
Your Honor, the people are satisfied with the factual basis.
The court is satisfied as well. I'll accept your plea and find to be freely, voluntarily, and intelligently made. Your matter is going to be set for sentencing January 10th at 9 o'clock in the morning. When you leave here, you need to go down the floor to the 5th floor. Check in with probation. They're gonna get you scheduled for your pre-sentence interview, okay? They'll also advise as to whether or not you're eligible for sentencing under 769.4. Do you have any questions at this time?
No.
Okay. Any additional matters for the record?
Your Honor, if I could address bond briefly. Your Honor, at this time, we would be asking for Mr. James to have third-party contact with Ms. Vanda in this case to be able to retrieve his belongings that are at the location where they were staying. He has some animals as well as some personal property there that need to pick up. Mr. James would like to have a family member go over there and retrieve those items. I believe Mr. Mercury did speak with Ms. Vanda this morning, and she did not have a problem with that. We'd also be asking for the removal of the GPS tether for Mr. James. I believe he hasn't had any violations, and since he's pled to a misdemeanor, I believe that I don't think a GPS tether is going to be needed to ensure his whereabouts or things like that. He's come to court, appeared on time. So we'd be asking for the removal of the tether as it is a financial burden.
Motion's granted. You can remove the GPS. Tell me you need to go back down to Ingham County for them to remove it. Don't remove it yourself. Otherwise, you get charged with a felon and you're gonna owe some money if you do that, okay? They'll remove it and then I'll allow you to have third-party contact for the purposes of coordinating removal of your personal items. Who is your third party?
It'd be my mother and my brothers.
Your mother and brothers?
Yeah.
Meaning your mother will make contact, but then your brothers will pick up the stuff, or,
They'll go together to pick it all up.
okay. Well, someone's gotta coordinate the time first, so who's gonna make contact with the victim?
It'll be my mother.
Okay. I'm saying that so that Mr. Markarian can let her know.
Yeah, it'll be my
She doesn't
mother.
need 3 or 4 people calling her to
Oh, no.
coordinate it. And then hopefully she'll make it available so that either she's not there or she's out of your way when it's time to come get your stuff, okay? Any additional matters to the record?
Yes, Your Honor, if I may, I understand the court's already made it. I just wanted to state an objection for the record on the victim's behalf to the removal of the GPS tether. She did specifically request that that stay on. I understand the court's already made its ruling. Regarding the items, I just wanted to put out there, she said she would leave them in the shed next to the house, not in the house. She's planning to have her father come over to put clothes, dressers, all the heavy, big stuff. That should all be there, but I'll let her know.
Thank you. Any additional matters to the record?
No, Your Honor, thank you.
No, sir.
Just have to see the hall.
I go talk to the victim.
On the record of the matter, the people of the state of Michigan versus Anthony Bywater 24-032229, council appearance.
Morning, Your Honor. Case Mark Carey, appearing on behalf of the people.
Good morning, Your Honor. Attorney Derek Esposito, public defender on behalf of Mr. Bywater, who's in the courtroom standing to my right.
Okay, today was the date set for a preliminary examination on assault with a deadly weapon and malicious destruction of property. How are we proceeding?
Your Honor, at this time, the necessary witnesses on this case, both Maddie Lawson and Tony Staley, have failed to appear. I've attempted to contact both of them multiple times from the phone numbers we have. Frankly, I've never even been able to make contact with them, so that people are unable to proceed. We would just ask that this be a dismissal without prejudice if we are able to make contact with them.
Your Honor, this time I would move the court to dismiss the case without prejudice. I've gone over the statute of limitations. Mr. Bywater understands it could be issued at a later time within that time period. I've also discussed with him the fact that there are possibly no contact order regarding this case. He understands he should not have any contact with him at least 24 hours so the matter can be removed from lien. Your Honor, he currently is on tether through and has a bond through a bondsman.
Okay, the motion to dismiss without prejudice is granted. You should give at least 72 hours though, to make sure this gets out of lane, okay? We'll get you a copy of the dismissal in just a moment. Do you have any questions? Additional matters? I'm sorry?
Nothing, Your Honor.
Yes,
Nothing from the people.
You should be able to take the dismissal.
we'll email Ingham County about the tether,
Okay, thank you, Your Honor.
so that you can go have that removed.
Just waiting on the dismissal.
I'm Mr. Mills is not here. I just wasn't aware of something.
Prelim to work.
Okay, yeah, we're gonna bring up Williams, I think. Ms. Schroeder has guns. Davis?
She does.
I have had contact with him actually just a few moments ago. He's had several matters unfortunately that are going on, and he's on his way here, Your Honor, and sends sincere regrets. It was gonna be a request, I believe, for a good cause adjournment. I did notify the court yesterday, or at least attempted to. I don't believe the prosecutor's objection. There is outstanding discovery that was requested previously, but I think in their changeover of their system, myself and Mr. Markarian have, and it's not just me from our office, there've been issues with getting videos turned over in a timely manner, and I think a lot of it has to do with their new system, and we are lacking that video. So we were gonna ask the court to find the cause regardless.
Yes, Your Honor, it's a joint adjournment request on that one. I did email our discovery unit yesterday, asking them to get those uploaded as soon as possible, and they said they sent an ASAP request to LPD, but it does not seem we have gotten that yet.
We'll wait to see if he shows up.
I also emailed the officers directly, so.
That's like,
We need Williams, bro.
Yes. I do have the victim here on the bar, Your Honor. She's in a conference room.
We'll handle Williams and then you can do that one.
Thank you, because Mr. Milks is still in Judge Ward's courtroom. I think he's running an exam.
Yes, please.
Okay.
Run out the hall for just one moment. Your Honor.
I'm sorry? It's not popping up. I don't know. Let's see. Let's see. Why did he tell you? I'm confused. Why is he telling you that? It's on me or? He needs to adjust it on my.
Okay.
Okay, let me see.
I approach.
Yes, do you need a defense attorney?
I just emailed Mr. Milks.
Oh, he's on the record.
Right, he's on the record and judge board, so I don't know if you want to wait until he gets here.
Well, it depends. Is it gonna be an ex parte communication if he's not here, or?
Yeah, you're right, probably. I'll wait for him. It's a procedural question, but I don't want
Oh,
to. But
we'll wait for it. I don't know how long he's gonna be, but he should be in his way. Seated. On the record, the matter of the people of the state of Michigan versus Dominique Williams, 24-03228, council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Morning, Your Honor, Attorney Derek Goodson, also the public defender on behalf of Mr. Williams, who's standing in the courtroom to my right.
Okay, Mr. Williams was scheduled to have a examination today for controlled substance possession. How are we proceeding?
Your Honor, the big request to adjourn from the prosecution on this one. I have not seen the complaining victim on this one, Madonna Pinder. However, my intent is to run this victim list, even if she does not show. And the officer I need for that is Officer Tori Brooks of the Lansing Police Department. She advised me that she is in training all week this week and unavailable. And they have a test on Friday that the training is for. She has to pass that to continue. So we would be requesting to adjourn.
And let me just be clear, because I was looking at another file, William, and read the wrong charge. It's weapons possession, assault with a deadly weapon on this matter. Do you want to respond to the people's motion?
Yes, Your Honor. Your Honor, I would ask, based on Mr. Williams' request, ask the court to dismiss the case. We are ready to proceed today. So he's asking the court to dismiss.
Motion to dismiss is denied at the officers in training outside of the prosecutor's control. So the court's going to find good cause to reset this matter. January 10th at 9 a.m. January 10th at 9 a.m. Have any questions for today, Mr. Williams? Any additional matters for the record today?
Nothing from the people.
Your Honor, we ask the court to entertain a bond motion. Please.
Bond is set at 15,000, 10%.
Yes, Your Honor, he is not able to post that. He is indigent and on food stamps. We're asking the court to grant a PR bond, 15,000 PR bond, and asking the court to order tether. He advised me with the food stamps, he can get the grant money to pay for tether, so there should not be an issue. He's advised me that he would live with his dad, Jerry Williams, at 300 A Street in Lansing, Michigan. He has a phone number. He did have some jobs that he didn't make very much money at prior to being arrested. At Woodbridge, he had a job there with limited hours and worked part-time at Chile with limited hours. He believes that quite possibly he could still have those jobs or go back to work at those places. I did discuss this with the prosecutor prior to going on the record, and I don't believe he has any objection to the court granting a PR bond with tether. So that's what we'd ask for requested court to do.
So weapons, firearms, possession by prohibited persons, and assault with a dangerous weapons, a felony firearm, habitual offender second offense notice, and the magistrate imposed a bond of 15,000, 10%. Also, there was a bond recommendation that was provided about a concern to the protection of the public because the crime involves violence towards another person, and the crime involves possession, use, threat of a firearm with an intimate partner. And it's unclear to me based on this report, but was there another bond or protective order on this matter at issue?
Not that I'm aware of. Your Honor. Doesn't appear to be so, Your Honor, based on what my client is telling me. I'll defer to the prosecutor who's looking at it.
One moment, Your Honor.
Your Honor, they had is from 2001, so it's a rather old case that they're using that habitual life.
And again, God bless you. The reason why I asked is because the affidavit of probable cause did.
See the 15,000, 10% bond you've referenced, Your Honor, by Magistrate Millmore.
Correct, but I was trying to understand, was there a PPO or another matter that protected the party? Because I was trying to understand why certain language was used. Even without that, I think the bond is relatively low considering the charges. 15,000, 10%, the GPS tether. Was again allegation of assault and a weapons by a prohibited party, assault with a dangerous weapon, that being a gun, and the information provided in the affidavit of probable cause was that the alleged victim sustained injury. Bond is really low. Personal recognizance bond would not be appropriate due to the concern for this public safety. I think the bond recommendation actually requested higher than that, but Magistrate Memo gave a relatively low bond. So no, I will not grant a personal recognizance bond. Any additional matters for the record?
Nothing from the people.
You're all set.
That's the one in the afternoon, right? Or are you on Bishop? I thought that was Palmer. Haven't been to a home run yet. That's what they say. Case reviews.
We're waiting for Mr. Mo. Yes.
I do believe Mr. Milks is still in Judge Ward's courtroom, but we have Mr. Gunn Davis here for the adjournment request. If you'd like to do that, Your Honor.
I'm sorry, I missed what you were saying. I was reading an email.
Mr. Gunn Davis is here, Your Honor. He did appear for the adjournment request.
On the record in the matter of the people of the state of Michigan versus William Gunn Davis 24-03226. Here's please.
Good morning, Your Honor. Case Mark Arian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder, appearing on behalf of Mr. Gunn Davis, who is here and standing to my right.
Mr. Gunn Davis, you oversleep today?
My alarm didn't go off. I'm staying in a hotel right now because my mom died. And I'm just up here dealing with a lot of stuff. And yes, just didn't go off.
I'm sorry to hear about your mom. So you're just up here, up where?
I got released from prison in Florida, and you know, I was gonna get a home down there and stay down there, but right before I got released, my mom died. So I'm next to kin, so I had to come up here and like deal with all her affairs, her home and all that stuff. So she was a renter, so I had to be out of her house, so I don't have any place to stay. So I've been staying in a hotel recently. And the alarm just, it didn't go off. And I opened my eyes, and as soon as it did, I called.
What address are you using now? Because we had a Tisdale.
1019 Tisdale, that's my answer.
Okay, so that's where your mail can go. Okay, sounds good. Okay,
I am gonna be, she actually did agree to let me rent the basement, so.
beyond, it doesn't allow you rent the basement. Okay,
So that's 1019 kids.
Yes, ma'am.
we have 1014.
1019. 48910.
We'll have that updated in our system to 1019 Tisdale. Okay, today was the date that was set for preliminary examination. How are we proceeding?
Yes, Your Honor, I believe we have a joint adjournment request on this one to request and review discovery. I did just get an email from our discovery unit at 10:15 saying we have finally gotten it and it has been shared, but I know that we're both gonna need some time to look over that before we do anything more on this case.
That is correct, Your Honor. We'd be asking the court find good cause for the adjournment basis. I thought we made on the public defender's behalf, at least on my end, made efforts to try to get this video before a few days ago at least, because I knew that they were having some difficulty with their new system changeover. And we did then put it in the request when it still had not been put in as of this week. And there's just been a delay, and it turns out the prosecutor didn't even have it in their system yet, so we would ask for good cause and got some time to do that. Thank you.
January 10th at 9:30. The court will find good cause to adjourn, that will be reset. 10th. Get your notice to appear. Do you have any questions today, sir? Additional matters for the record, counsel.
Up to the people.
Enough for the defense, Your Honor. Thank you.
There you go, sir.
We're good. Are we, he's gonna get a printed copy of this. We just need to-